I guess Randy says that when you look at the framers and you look at the interpretive rules, that sure, they don't mention the term construction, but, and even today a lot of people don't use the term construction, but when you figure out sort of what they're doing, it maybe really is construction. And I guess I think we disagree on that matter as well. I think in order to have evidence of construction, one would, you certainly don't need the exact term to be used of construction, but one wants to get a sense from the people at the time that they thought the concept of construction was being employed. One wants to hear them say something like, okay, you know, the meaning runs out, right? We're allowed to, and what we bring into this is our, you know, what are the correct normative views, right? And some understanding of this notion of construction. And I guess I just don't see that in the framing materials. Maybe there are examples of it, but I don't think anyone's sort of brought them to bear yet. And so, I mean, I guess, you know, if they followed construction interpretive rules, then original methods would incorporate construction. But I just don't see any evidence that they do that. Instead, when they have close cases, when they're thinking about, you know, the arguments on this side are strong, the arguments on this side, you know, this is a difficult case, they don't say, oh, well, we're not sure how to resolve it, we'll just pick the one we like better. They say it's a close case, but we think the evidence is stronger, right? And that conveys to me an idea of interpretation rather than construction. And I guess I'll just finally, this last point Randy talked about with respect to first principles. And he mentioned a series of cases where the court seems to talk about first principles. And I'm not, you know, they were a variety of cases. But I'll just talk about Marbury for a second. My understanding of the talk about first principles in Marbury is that what Marshall is doing is trying to give an understanding of what the meaning of the terms constitution meant and what its normal incidence would be, and that constitutions take priority over statutes, right? So it's, in other words, those principles were built into the terms. When you use the term constitution, it was understood you meant something that had priority. So I don't think of those references in Marbury or most of those other cases as bringing something external to the Constitution, but instead an explication of the terms in the Constitution.
That's Mike. Well, I think I can make, can everybody hear this? Okay, I think I can make this response somewhat quick, because I think the area of our disagreement has really been made quite clear. The first has to do with vagueness, and whether you actually think vagueness a vague term has more information in there or less information in there, whether you think the information provided by a vague term does run out and require supplementation, or you do not. Mike thinks it does not, and I think that it does, and I think it's hard to come up with, you know, specific examples that are proof positive, and you're going to have to leave this, you're going to have to make up your own mind about whether you think vague terms actually have a more specific meaning when in application. So for example, this may not even be the best example, it's the one that just popped into my head. Thermal imaging of a house. Search, not search. Mike wants us to look at the evidence to decide that. Evidence of what? Evidence that a thermal imaging was included or not included. Is on one side of the line, not on the other side of the line. I don't think that, it's an epistemological question. It's not an epistemological question. It's not something you go back in history and figure out thermal imaging is a search or not a search. They didn't have thermal imaging in their head. So we don't have evidence of what they had in their head, assuming that was even the way you'd want to do it. So that maybe there's something in the meaning of search that really dictates that thermal imaging is in and out and does not require construction. I would like to see as much brought out in the form of interpretation as possible before you ever move to construction. So that's why I'm not sure this is the best example, but at least off the top of my head, it's an example of where, historically at least, you're not going to ask that question the way originalists used to ask that question. So there's a basic disagreement there about the problem of vagueness and how it differs from the problem of ambiguity. When you are actually in the vague penumbra of a word, there is no there that can be uncovered by means of extrinsic, by means of historical evidence. Okay, but now I really think I know what the real disagreement is between, that is a major part of the disagreement between Mike and John and me, but there's another even bigger thing that we disagree about. Notice all that Mike talks about, or principally what Mike talks about with respect to construction, is coming in with your normative theories. Importing your normative views about which one can't, we're going to disagree about, okay. Essentially, I think what Mike is really disagreeing about is that method of construction. He doesn't like that method of construction. And that's a debate worth having. That might be an objectionable method of construction for, I would say, extrinsic considerations like rule of law considerations or lock-in considerations or other kinds of, in other words, he might have a normative argument to make against using normative arguments when doing constitutional construction. That's a very reasonable position to have, but it is not a position against all constructions. To reject the opposing view of bringing in normative judges should not be able to bring in normative considerations, to say that's objectionable, is not to refute the necessity of doing construction somehow. Maybe not that way, but by some other way. Like what? Well, for example, you could try to find principles that underlie what the text does say. The text doesn't say those principles, but they underlie those principles. You take those principles, you use those principles in ways that would be more constraining, let's say, than just what Mike attributes to me, this view of just bringing in your normative considerations. By the way, I'm not sure I really want to accept that whole characterization of my view, but I'm willing to do so for purposes of seeing what's really being contested here. So there may be lots of ways of doing construction that look so much more constrained than what Mike is rejecting that Mike characterizes them as rules of interpretation. But that doesn't make them rules of interpretation. They still may be rules of construction. And they just might be more constraining ones that fit Mike's normative framework. I mean, the last thing I will say about normativity and the fact that we're all going to disagree about what's normative and what's not normative, what's normatively appealing, of course. However, I insist we're going to disagree about what's normatively appealing about the Constitution and what makes it legitimate. We're going to, for example, if you think consent is what legitimates the Constitution, we're going to disagree a lot about what constitutes consent, a lot. So there's a lot of disagreement out there. And it's normative in many cases. Sometimes it's descriptive, but most of the time it's normative. And there's no way to do away with normative disagreement. It's gonna come in no matter what you do to try to keep it out.
Thank you very much. And so for folks who would like to ask a question, please identify yourself, where you're from, and do we have a microphone as well? And get the microphone as well.